This is Judge Goldblatt. We are now on the record in Ray Allegiance Coal USA Limited, which is case number 23-10234. We are proceeding this morning by way of Zoom. As a result, I ask that folks leave your microphones muted unless you're addressing the court or wish to be recognized. I'm sorry, to leave your microphones muted unless you're addressing the court, that you introduce yourself for the record each time you address the court, and that you generally leave your cameras off unless you're either addressing the court or wish to be recognized. And if you do want to be recognized, please turn your camera on and I'll recognize you as soon as I'm able to. So with that, let me pass the virtual podium to counsel for the debtor to take us through our agenda this morning.
Thank you, Your Honor. Can you hear me all right?
I can, Ms. Tucker. You can proceed.
Thank you. And for the record, Paige Topper, Morris Nichols, Armstrong Tunnel, on behalf of the debtors in these Chapter 11 cases. Your Honor, with me in the virtual courtroom today is my colleague, Dan Butts, as well as I see on, in the Zoom courtroom today, Mr. Chris Walker. He is both the Chief Restructuring Officer and Chief Financial Officer of the debtors. I want to start by thanking the court for accommodating this hearing, and in particular thanking the court for the flexibility in adjourning this matter several times to allow the parties to negotiate. I'm pleased to report that we are here today on what I believe is a consensual proposed final DIP order. So we do have that one matter, Your Honor. It is only the final order for the debtor's DIP financing motion going forward today. Before I turn to the motion, Your Honor, I do want to provide the court with an important but short update of what's been happening in these cases.
That would be very helpful. Thank you.
Great. So since we were last before Your Honor with respect to the initial interim order on the DIP financing motion, a fair amount of changes have occurred. Unfortunately, not all of them have been ideal. Despite the company's efforts to stabilize their business operations in the Chapter 11 cases, external factors have continued to pose challenges and have required certain operational changes necessary for the debtors to proceed going forward in these cases. Notably, the debtors have had difficulty executing coal sales, and the market price for metallurgical coal has declined recently. As a result, and in consultation with the DIP lender and the committee, the debtors have made the difficult decision to transition both the Black Warrior and New Elk mines into care and maintenance mode. I will note that although this means that the majority of the company's workforce have been laid off, it's happened, Your Honor, in the past 2 weeks. 2 weeks roughly for Black Warrior and last week for New Elk. A skeletal workforce does still remain at each mine to both maintain the mine and, comply with any environmental responsibility and the regulatory responsibilities. The debtors are continuing to market their business. That was highlighted. We proceeded with Capstone as the debtor's financial advisor to conduct a post-petition marketing process. That post-petition marketing process remains ongoing, and the debtors remain hopeful that there will be a sale of those mines and or the related operating assets associated with each of those mines. To that end, Your Honor, the debtors have reached an agreement with the committee and the DIP lender on the proposed final DIP order that's before the court today, and that's to provide the company with the necessary funds to pursue a sale transaction in these cases. Unless the court has any questions on the update, Your Honor, I'll proceed with the motion.
If I can just ask this one question. So I saw in the most recent red line of the order that references to ongoing negotiations over the budget. I take it that's the budget necessary to conduct the sale process. Do I have that within the ballpark of right?
Correct, Your Honor, with one caveat. I will say that and I was going to touch on this, and we recognize that it's a bit unusual to have a 1-week budget attached to a final DIP order, but if you look at footnote 7, I believe, in the final order, references that the debtors and the DIP lender, along with the committee, have reached an agreement that we will continue to negotiate an updated budget. The reason for continuing to negotiate that updated budget and the reason for only doing a 1-week budget in the first instance is because indications of interest have been requested as due this Friday. So the company, along with the DIP lender, have decided that it's most efficient and the most effective way going forward to see what comes in on Friday before sort of working on an updated budget over the weekend and agreeing to something a bit more concrete.
Okay, that makes sense to me. I follow. Okay, so you can proceed. Thank you.
Okay, thank you, Your Honor. And so with respect to the final order on the dip motion, Your Honor, I would just as a housekeeping matter ask that the court take notice of the record at the interim hearing that was several weeks ago with respect to the declarations that were previously admitted.
Yeah, so is there any objection to treating as part of the evidentiary record today the declarations and other evidence that was admitted into evidence in connection with the prior interim dip motion? Okay, seeing none, that will all be incorporated into today's record.
Thank you, Your Honor. And with respect to the proposed dip order, Your Honor, I was going to highlight that 1 week budget that you've already noted. As I mentioned, and as noted in the proposed order itself, the current budget does expire at 11:59 p.m. on May 21st, but the debtors, as I mentioned, have agreed to negotiate on a further updated budget. Importantly, that budget, to the extent that it's agreed upon, will be filed under a separate notice with the court, so parties in interest will have access to the updated budget. What will also be filed is, in connection with that notice, revised variance reporting to the extent necessary. And again, Your Honor, that's just the parties have agreed to sort of push off the issue of variance reporting until after indications of interest come in, so that we can see what changes, if any, are needed to the variance reports. The proposed dip order, Your Honor, also does address the settlement and, includes the settlement between the committee and the dip lender. When I'm done, I will let the committee's counsel address their settlement terms with the court. I did want to note that in addition to the committee's informal comments, the debtors received a limited objection from Huddleston Resources LLC, which is a mineral lessor at the Black Warrior mine. The debtors had previously resolved Huddleston's limited objection through language in the proposed order. It's located in the final order at paragraph 44. It has been included in sort of the subsequent interim orders that have been entered by the court. I had received confirmation from counsel for Huddleston this morning that they do not object to entry of this proposed final order. I also want to note for the record that I was in communication with Mr. Fox this morning at the Office of the United States Trustee. He has informed me, or authorized me, I should say, to let the court know that he apologizes for not being able to attend today's hearing, but he had a conflict with a 341 meeting in a separate matter. He did authorize me to inform the court that the U.S. Trustee's Office does not object to entry of the proposed final order before the court today. And then finally, I have received, separately again this morning, confirmation from counsel for Klein Mining Corporation that they also do not object to entry of the proposed final order. So I'm happy to walk through the changes to the proposed final order, Your Honor. If you have any questions, we filed it late last night. So I'm happy to walk through the red line if necessary.
So I was able to review the red line this morning, and I asked you about the one question I had to understand the budget, but otherwise I thought the changes didn't raise concerns to me if it's all agreeable to the parties. So no need to go through the red line for my sake unless you feel a need to make a record for any reason.
Not from my end, Your Honor. I guess I'll take this opportunity, if the court has no other questions, to cede the virtual lectern over to anybody else who wishes to be heard.
Okay, very well. Thank you, Ms. Topper. Mr. Gaffey.
Morning, Your Honor. Dave Gaffey of Whiteford, Taylor, and Preston, counsel to the committee. The committee supports entry of the proposed final order. The order has been heavily negotiated by all parties as late as last night and represents a compromise of many issues. It enables the debtors to complete an orderly sale process for their assets, which is important for unsecured creditors in this case. It also includes a settlement with Collins of the committee's objections to the dip motion. I'm happy to run through that settlement briefly if Your Honor would like.
Why don't you highlight the key terms, make sure I'm following.
Yes, Your Honor. The settlement centers around a marshaling concept for non-debtor assets for the benefit of the estate. Collins' debt is secured by the debtor's assets as well as a Canadian mining project called Telqua that is owned by the debtor's parent company that's not in bankruptcy. Telqua is in the process of being sold by the Australian equivalent of a receiver. What our settlement does is it marshals $5.5 million of the U.S. sale proceeds initially, puts them into an escrow account, which amount steps down if there isn't a binding APA for the telco assets within 90 days, within 120 days, and then steps down further in 90-day increments if there's no APA going forward. This gives us up to 300 days to use the telco assets to reduce Collins' debt and preserve up to $5.5 million for the benefit of the debtors' estates. The agreement also gives the debtors 9 months from the petition date to pay Collins' claim before Collins can look to proceeds of avoidance actions or commercial tort claims. In exchange, Collins' stipulations and releases that ordinarily would be subject to our challenge period would be immediately effective. The committee's analyzed the potential claims that we could bring against Collins and the likelihood of success of each, and we believe that this settlement is the path forward that's in the best interest of unsecured creditors in this case. So with that, the committee does support entry of the proposed order.
Okay, that's very helpful. Thank you, Mr. Deck.
Thank you, Your Honor.
Is there any other party in interest that would like to be heard with respect to final approval of the DIP?
Yes, Your Honor, this is Mr. McRoberts, Ms. Wire Patent Box.
Yeah, you can proceed, Mr. McRoberts.
Thank you, Your Honor. As you know, we represent and congregate the DIP lender in these Chapter 11 cases. I just wanted to briefly speak to indicate we also support entry of the final DIP order. I believe it's an important milestone case, and obviously, as Ms. Hopper indicated, we have some important work to do over the next couple days, but it's very encouraging that the parties, at least from my perspective, we're here, we're together, we're generally rowing in the same direction. So again, we appreciate your indulgence and your time and your patience with us the last few weeks, and also support entry of the order.
Okay, thank you, Mr. McRoberts. Is there any other party in interest that would like the opportunity to be heard with respect to the motion to approve the DIP order? Okay, if not, I have, as I noted, reviewed the order, including the changes that came in by red line. Ms. Hopper said they came in last night. I confess I looked at them this morning. I'm satisfied that the relief sought is appropriate, that the parties have worked together to reach a resolution of various issues. I appreciate that there's work still to be done, but I'm persuaded that the relief sought is appropriate and that the parties should be left to see if they could hammer out the remaining details, and to the extent they're able to do that, then everything can proceed, and to the extent an issue were to arise that requires the court to address any issue, of course we're available to do that. We will go ahead and enter the final order whenever it is uploaded. Ms. Hopper, is there anything else on the agenda this morning?
No, Your Honor, that was it for this morning's hearing.
Okay. While we're here, is there any other matter in the cases that I should know about or in which the court can be helpful to the parties?
Not from the debtor's perspective, Your Honor. Thank you.
Okay. Thank you. Seeing no one else, let me thank all of you for the good and hard work. I appreciate the challenges, but it seems like everyone is doing the best they can under the circumstances, and all of that hard work is appreciated. So obviously, to the extent you need me, you'll know how to find me. But with that, let me allow you to continue your work, and with my thanks, we're adjourned. Thank you.
Thank you, Your Honor.